Okay, good day, everyone. I don't know, can you all hear me, please?
I can hear you. Onye, can you hear her? Temitayo, can you hear her?
Okay.
Yes, I can.
Okay, that's perfect. So today we are going to be spending our nights on three related but distinct areas of law, right? Like Barrister Ewa said, I'll be taking the enforcement of fundamental rights under the Constitution. Then I'll also be taking the rules on costs and sanctions in civil litigation. Then I will be taking judicial review together with the prerogative orders like certiorari, mandamus, prohibition, and habeas corpus. So I believe that by the time we are done today, you should be able to at least do four things. You should be able to explain the general principles, the procedures, and scope of fundamental rights enforcement procedure rules. And then you should be able to tell me which courts have jurisdiction to hear these matters. Also, you should also be able to, to actually sit down and draft an application under these rules, because I believe that at this time we need to start learning our drafts. Exam is fast approaching, and draft is one of the things that takes major marks in law school. So then you should be able to also explain in clear terms how fundamental rights enforcement differs from, judicial review and from other writ of other judicial reviews like writ of habeas corpus and the likes. So before we actually talk about the procedure, we need to first appreciate the sources of the rights we are trying to enforce. Because a lawyer who does not know his sources is like a soldier who has gone to war without knowing where exactly his weapons are kept. So the first and most important source is the Constitution of, the Federal Republic of Nigeria, and specifically that chapter 4 of that constitution. That's the most important thing for this our fundamental rights discussion. And now, fundamental rights, like FREP in general, also relate to African charters on human and people's rights, because it has now been domesticated into our laws. And we will eventually spend time on discussing this African charter and also the chapter 4 and the likes. So, now, a particular question that literally troubles young lawyers is what happens when the fundamental rights rules are silent on an issue? So, ordinarily, where the ordinary rules of courts comes in as a backup. So, in a situation where the FREP rules is actually silent, they refer back to our ordinary rules of courts. So, what I'm talking about here is the civil procedure rules of different courts like the Federal High Court, the National Industrial High Court. So where the FREP rules is silent, we can fall back to that. So the rules themselves anticipate the problem and it also answers it directly. Now, Order 15, Rule 4 of the Fundamental Rights Rules is what we literally call a transitional provision. And it says that where in the course of any human rights proceedings, a situation arises for which there is no adequate provision in the fundamental rights rules, then the civil procedure rules of that particular court will take place. So now the fundamental rights rules are like the specific rules for anything FREP, anything fundamental, anything when chapter 4 of the Constitution, African Charter rights and the like. So we most likely make use of fundamental rights rules. But where the rules are silent, we can make use of our civil procedure rules. Now, it is also important for you to know the difference between the old rules, which is the 1979 rules, and then the 2009 rules. Now, previously, when a litigant is trying to, go for a fundamental, a FREP matters, they need to establish their local standard. I mean, why are you here? But right now, the 2009 rules has been able to say that you don't need to show locus. So the fact that you had just showed sufficient interest is enough. You don't need to show that you are personally affected by that incident. So, and in the old rules, that's 1970, there used to be a limitation period where you have to bring your action, or you cannot, you'll be status bad. But now there's nothing like that. So, and then before, they used to require like a leave of court to actually bring a fundamental rights issues. But at this point, you don't even need any leave of any court. You can walk into any court and then start your fundamental rights issues. So there are different things, a lot of differences between the old rules and these new 2009 rules. So we can read more on that, but I've just stated the major differences. So now I will be moving to the legal status of the FREP rules. So I think in the case of Abia State University and Chima and Yebe, where the courts of appeal heard that where there is any clash between what the fundamental rule says and what an ordinary rule of court says, then the fundamental rights rules will prevail. So the reason for this is that I feel like I'm just talking to myself.
Please can we hear her? Temitayo Onye.
Sorry. I'm so sorry. So my younger brother called, so it disrupted me.
Oh, okay.
Disrupted the call. I'm so sorry.
Okay.
Can you hear me now?
Yes, I can hear you.
Okay. So the court stated clearly that rules made pursuant to constitutional provisions also possess constitutional flavor, and that is specifically that is why when there is a conflict between maybe for the FREP and then the court rules, FREP will actually prevail in this instance. Do you understand? Okay, so then you may also be asked that. Okay, so you may also be asked that, is a person compelled to use the fundamental right procedures, or can he actually enforce his right through some other method entirely? And then the answer will be that a person is not actually compelled to use the rules, because any mode available under the ordinary rules of courts or even any common law is equally permissible, because the law just wants justice. The law is not being so hardened. In as much as you are able to access justice, that's the primary basis of the FREP rules in itself. So any mode you use will definitely be acceptable. So now we also need to talk about who can actually bring the fundamental rights actions. That is the parties to fundamental rights enforcement actions. Now, Section 46 of the Constitution already defines the applicant as any person whose rights are being or are likely to be infringed. So I don't know, Lagos campus, they made this one, you have to memorize it. So I don't know, but if you are able to get that language the way it is, then it's going to help you. But the 2009 rules actually went further. Section 46 just said it's in that language, but 2009 rules went further than this and significantly relaxed the strict requirement of local standard. Now, under paragraph 3E of the FREP rules, it's provided for the categories of people that can actually sue. So first of all, the person directly affected, a person acting on behalf of another person, a person acting as a member of or in the interest of a group, then a person acting purely in the public interest. Just in as much as you can show that this you have interest in this thing, you can go to court and then the court will hear you. And now we also need to talk about joinder and consolidation of parties. Now, on the question of joinder, where two or more persons whose rights have been jointly infringed, whether they can sue together in one action, yes. Even companies and incorporated bodies can sue and also be sued under the FREP rules. When it relates to persons under legal disability or like an infant, then they can sue through a nurse friend. But in a situation where the person is dead, that is the the directed affected party is dead, then fundamental rights cases is always in personam. So you can only claim damages. You cannot go deep into fund and FREP like that. The court will not hear because the person affected is dead. So there's no point. So that's it about when it affects a deceased person. So now we should also talk about what exactly is the cause of action. Now, other two rule, one of the FREP rules gives us the cause of action in fundamental rights enforcement. It specifically states that any person who alleges that any of the fundamental rights provided for under the Constitution, that is, under that Chapter 4 and under the African Charter, is being or likely to be infringed, may apply to the courts in the state where the infringement occurs. Excuse me. Now, there's also a proviso to these provisions. They say where the infringement occurs in a state that has no division of the Federal High Court, then the division of the Federal High Court that is administratively responsible for that state will exercise jurisdiction instead. So what this means in simple terms is your cause of action is the actual or threatened breach of your rights guaranteed in the Chapter 4 of the Constitution or under the African Charter. So the place to actually sue is generally where that breach has happened or is about to happen. That's where the jurisdiction lies on. So now, I believe that we understand what we have been saying about Chapter 4 rights, because everybody is not new to us about the rights contained in Chapter 4, Section 33 to 47, and the rights contained in the African Charters, because those are the specific rights that at the point where it gets breached, then we can apply to court for fundamental rights. Now, what cannot actually be enforced under these fundamental rights rules is, let's take for instance, wrongful dismissal or termination of appointment. Can such action be commenced under the fundamental rights rules on the theory that the person has a right to work? The answer will be no, because a dismissal case is fundamentally a labor or contractual matter, not a breach of a chapter of Chapter 4 or the African Charter. So it must follow the ordinary route. Typically, this one will typically be before the National Industrial Court and not the fundamental rights rules. So another example is chieftaincy disputes, where chieftaincy dispute is brought under the FREP rules. That one too cannot work. Chieftaincy matters are governed by their own specific statutory and their customary framework, and they do not, by their nature, constitute a breach of Chapter 4 rights. So I believe that aspect is quite clear. So I also need us to understand that fundamental rights enforcement proceedings are what we call sui generis, meaning that they are the class of their own. They are very unique with their own special character. And because of that special character, in both commencing and defending such an action, the rules become extremely strict, just because they have their own specific way of how it can be done and the things to be done. Now, Order 9 deals with what is called the effect of non-compliance. Order 9 provides that where at any stage of proceedings there has been a failure to comply with a requirement as to time, that failure, maybe time, place, manner, or any form, that failure shall generally be treated merely as an irregularity, and it will not automatically nullify the proceedings. So there are, however, two important exceptions where non-compliance will actually become a bit difficult. So the first part is where the non-compliance concerns the mode of commencement of the application itself, and where the subject matter of the application is not actually one that falls within Chapter 4 or the Constitution, the African Charter. Now, we should also talk about the courts that has jurisdiction. Section 46 of the Constitution, like I said earlier, and other 2 of FREP rules, if read together, already tells us which court specifically has jurisdiction, and the court that has jurisdiction is the High Court. Now, it can be state High Court or federal High Court. Now, federal High Court, you go to federal High Court when the subject matter relates to the list of items as contained in the jurisdiction of the federal High Court in the Constitution. That is when you will be able to go to the federal High Court. But majorly, the High Court, the state High Court and federal High Court have jurisdiction for fundamental rights enforcement procedural rules actions. Now, how do you actually commence this action? So the application may be brought using any originating process that is generally acceptable to the court. But whichever process you choose, Order 2 Rule 3 requires that it is accompanied by some certain essential documents. So first, there must be a statement of facts. And this statement of facts must contain the name, the description of the applicant, the relief being sought, and the grounds upon which those reliefs are sought. Now, for second, there must be an affidavit setting out the facts upon which this application is actually brought. And then the third thing is that there must be a written address that is arguing the grounds upon which the application is brought. Now, let's talk about the filing and serving the application aspect of FREP. Upon filing the application, you have to pay the necessary filing fees and do the necessary things, attach your stamp and seal and the likes. And then you need to make copies for service. Now, as for service, the process must be served on the respondent. And the ordinary rule is that this is done personally by the sheriff or bailiff. But one useful point to note is that service on the respondent's agent is regarded as good and valid service as well. So you do not necessarily need to start hunting down the respondent personally in every situation, provided his recognized agent is properly served. So sometimes personal service is not practicable. Like perhaps some respondents are intentionally evading services. They do not want to be served, and they are even unavailable for you to locate them. So in such situation, whether or not you have attempted to personally serve them at first, if it appears to the court that personal service for this type of case cannot be effected, the court may order substituted service under the Order 507. So you also need to note that where service has to be effected outside the state where the action was filed in another state, that cross-border service must comply with the normal Section 97 of the Sheriff and Civil. I'm sure we would have done that. The normal procedures for Section 97 as provided in Section 97 of the Sheriff and Civil Processes Act. Now, what happens after service? A respondent who actually wishes to oppose the application must file a counter affidavit. If you intend to oppose the application that has been brought and served against you, you need to file a counter affidavit together with a written address, and this has to be done within 5 days of service. And after you file this, you must serve the applicant. So you need to also note that if the respondent fails to file a counter affidavit or fails to file his written address, it will actually weaken his position, because the court will just presume that all the facts sworn to by the applicant is deemed admitted by the respondent. By his silence, you refuse to respond or file any counter. It means that you accepted everything that has been stated against you and you want us to proceed. So we also need to understand that once the applicant has been served, I'm talking about when the respondent now intends to oppose the application brought against him, the applicant may also file a reply on point of law and then further affidavits, but everything with respect to how we have been taught on how the procedures for serving reply and further affidavits in the previous topics we've handled. Now, let's talk about handling cases of urgency. Now, where there is a real urgency, particularly a threat to someone's life or liberty, the applicant can move by way of an ex parte application. So for the ex parte application stage, you just file a motion ex parte an affidavit and an affidavit of urgency, and then a written address. So this basically required under Order 4 Rule 4. That's where it is stated. So for the substantive stage, after you have served everything, all of this, because it requires urgency. When you get to substantive stage, you would additionally now file a motion on notice, an affidavit, a statement of facts, and a written address, just like the one we've stated initially. Now, how is this application actually held? Order 4 governs this the hearing of this application generally. The rules requires that the application be fixed for hearing within 7 days from the date it was filed. So all of these days we actually need to take notice of it, because it can come out in our OBJ MCQ. They can ask how many days, all those days. We just try to put it down and note it down and understand the differences. So for FREP, adjournment is actually is permissible though, but it is genuinely and extremely, it is only when it is genuinely and extremely expedient to actually do so. That's when adjournment will be allowed. But the hearing itself is usually within 7 days. They want the court to be done with it. So for PO, preliminary objection, Order 8 governs that preliminary objection generally. And where a party wishes to challenge the jurisdiction of the court to entertain the application, he must, in addition to filing his notice of PO, that is his notice of preliminary objection, he must also file his counter affidavit and written address responding to the main application. So that on the actual hearing date, the preliminary objection and the main application are both had together. We will not allow you to waste our time. So that is why they brought this rule that you bring your PO and the main application. So we hear it together and we will determine the case. So now, what relief can the court actually grant? I believe that we all understand the type of relief the courts can actually grant for this case. The reliefs available in fundamental rights are actually broad. They include declaration, injunctions, equitable remedies like habeas corpus, mandamus, prohibition, and certiorari. Then the courts can also give order of production. They can give order of access to medication, and they can give order of release, and so on and so forth, depending on the situation of the case at hand. Now we should actually let's talk about the costs and sanctions available. Now, what exactly is the purpose of an award of costs? Fundamentally, costs exist mainly to compensate a party, usually the successful party, for the expenses he has incurred in the course of action. So this will typically cover the cost of his legal representation, as well as maybe the travel, the out-of-pocket expenses, everything. So now, when the court orders that cost to be paid, the judge is expected to summarily determine the actual amount payable at the very time he delivers that judgment. So, and then there's also a very firm rule about timing. So where costs are ordered to be paid, they become due and payable immediately and must be paid within 7 days of the order. So now, if the party that was ordered to pay defaults, that defaulting party or even his legal practitioner may be denied further audience in that proceeding until the costs are settled. That's how important costs can be. And now we also need to understand that costs are always at the discretion of the courts. It is worth repeating clearly that the award of costs lies entirely within the discretion of the courts. Courts generally follow the event in litigation, meaning that a successful party is ordinarily entitled to its costs. So unless there are special reasons why it should be deprived of that entitlement, but the courts are also the courts are also being conscious that this discretion is not to be exercised arbitrarily. Like in making an award of course, the court must act judiciously and judicially. If you are always going to court, you will see how the court is always trying to ensure that you need to show to me why you are entitled to this cost before I will award you this cost. So now let's talk about the factors considered in awarding cost. So what does the court actually look at when deciding how much to award as cost? So the cost looks at certain factors such as like the summons fees that we actually paid, maybe the duration of the case, maybe it has been a case of 5 years. They look at the number of witnesses the successful party has called, the nature of the case, different things, the legal representation and the likes, before the court will actually award cost. Now, there are actually different types of cost orders. So, first, there is an order as to cost of action, just like the one we said previously. Now, the second one is there is what is called no order as to costs. And this simply means that neither party is to pay the other anything. Each side simply bears its own costs and expenses. That's it. Now, for the third one, we have cost in the course. Now, this type of order is made at an interlocutory stage. So essentially, the cost of the interlocutory application is held in suspense and simply follows whatever the ultimate outcome of the main case turns out to be. Now, the fourth one is there is cost in any event. Cost in any event. That's the fourth one. This one is also made at an interlocutory stage, but in a slightly different scenario. It typically arises where a party, because of its own failure to comply with the rules, has to bring an application to regularize that failure. So upon hearing such an application, because we order that party to, because we now order that party to pay costs in any event, meaning regardless of whether it ultimately succeeds or fails in the main case, you have to pay that cost. So that's it about the cost in any event. So for sanctions in this context are like penalties prescribed by the rules of court, payable by litigant to the court itself as a consequence of their non-compliance with the rules of court or with those rules. Now, let's talk about judicial review. Judicial review is actually the process by which superior court exercise supervisory jurisdiction over inferior courts and over the executive and the legislative as well. So it's just in order for them to be able to checkmate and curtail any constitutional breaches or excesses on their path. So basically, what judicial review is a kind of quality control mechanism that the courts exercise over the actions and decisions of public bodies to make sure those bodies stayed within the boundaries of the powers given to them by law. I believe this should be clear. So now the guiding principles of judicial reviews. There are actually several important principles that guide how courts approach judicial review. The first and perhaps most important principle is judicial review is not an appeal. You need to understand that judicial review is not an appeal. In an appeal, the appellate court is essentially asking, did the lower body reach the correct decision on the merits? But in judicial review, the correct focus is not on whether the decision itself was correct, but rather on the manner in which the decision was reached. So what actually matters in judicial review is legality, not correctness. So now, let me actually give you an illustration to actually cement this distinction firmly in your mind. Imagine a university disciplinary panel expels a student for alleged examination malpractice. So now, if the student appeals, an appellate body would ask, was the student actually guilty of this malpractice? And was the expulsion correct and proportionate punishment? But if the student instead requested for a judicial review, the court will not be asking whether the student was actually guilty or whether expulsion was the fairest punishment. The court will be asking whether the panel followed the correct lawful procedure in reaching that decision. For instance, whether the student was given a fair hearing. Do you understand? Whether that panel had the legal power to expel him, if at all, and whether it even acted within its boundaries of jurisdiction at the point of doing the whole process. So even if the reviewing court personally feels that the panel's decision was harsh or perhaps it was even wrong on the facts, that alone is not a ground for judicial review, provided the panel acted within its lawful powers and followed a fair procedure. So the prerogative orders and writs. So the first one is the certiorari. So this is simply a writ or order by which a higher court reviews a case that was tried in a lower court with a view to quashing that decision if it is found to be unlawful. Now, the second prerogative remedy is habeas corpus. Now, this is a writ issued by a court directing whoever holds another person in custody to produce that person before the court, usually to justify the legality of that detention. Now, the third is prerogative prohibition. Now, this is a prerogative order that seeks to restrain an inferior tribunal or an inferior body exercising like a quasi-judicial function from exceeding its jurisdiction or its powers. So, for this one, unlike certiorari, which actually looks backwards at a decision already made and quashes it, prohibition looks forward. It is aimed at preventing the continuance of an unlawful judicial or quasi-judicial act before it is even completed. So then the fourth prerogative remedy is mandamus. So this one is a prerogative which directed at like a public body or some persons or agency compelling the performance of a public duty that the person or the body is legally obligated to perform, but has refused or neglected or feel like nobody can force me, to do. So then I think that should bring us to the end of the class. And I also, my own advice for everyone is to try as much as possible to learn the fundamental rights draft. It is very, very important because I remember during our time, fundamental rights draft came out and it takes a lot of marks. So please let us try to learn. If you don't want to even learn the whole body, try to learn the basics, the first thing, just everything in the way it should be, so that you at least have idea of how it is well arranged, and you can even draft it if at all it comes up in your exam. Thank you.
Thank you so much, Mariam. Thank you so much. I really appreciate your time because I know that even being here for you is not very easy, and I am aware of the sacrifice that you had to make for this class. So I'm very grateful for how exhaustively you also handled this particular, because truly I said, and I think I have told them before now about how topics like this one forms like the things that really come out of exam. In fact, I think now in law school they will call it like one of the big fives: fundamental human rights, maritime, matrimonial courses, election petition. So imagine taking this kind of class. It's very, very important. It's something that will usually come out whether in your MCQ or in your theory. So please, after this class I have had today, please go back to your notes, practice, read, try your hands on your drafts because it's very important. These lessons are not hard, but they become hard for you if you don't practice. So thank you so much, Miriam. I really, really appreciate your time and efforts for today's session. Thank you so much. Oh yeah, and Temtayo, do you have any questions or anything you like Miriam to be aware of? Oh yeah, Temtayo.
No, I don't have any. I'm just grateful to be here because hearing someone speak about this topic is making me want to now like go ahead and do it.
Okay. That's quite good to hear. That's good to hear. Thank you so much for sharing your comments. So I guess at this juncture we can call it a night. Please don't forget to go through all the courses that you've learned today, from civil litigation to criminal litigation, property law, and corporate. And of course, what you did over the weekend, that's on Saturday yesterday. And please also prepare to come on time for the next classes so that it's not eating to our time and we can also finish on time. So thank you very much for joining today's session. See you next week. And by God's grace, I'll try to share some of these recordings on YouTube, preferably so that you can hear some of these sessions after now. So thank you so much everybody for joining. Thank you, Miriam. Thank you, Oye. Thank you, Semitayo. See you next weekend, this coming weekend. Have a wonderful night. Bye for now.